Good afternoon, everyone. Welcome to Venable, and welcome to our program today entitled Election Year Advocacy, Maintaining Your Nonprofit's Clear Message in Cloudy Legal Seas. My name is Jeff Tenenbaum, Chair of the Nonprofit Organizations Practice here at the Venable Law Firm. We appreciate you joining us on this pretty dreary, rainy day in Washington, and the 175 or so of you on the telephone from across the country. We appreciate you dialing in for today's program. As many of you know, this is part of a monthly series that we have been doing now. April of 2011 was when we started, so it's been 3 years this month that we've been doing these monthly programs on nonprofit legal issues. We always host them here in our D.C. office from 12 to 2 p.m. Eastern. Always, if you're around, feel free to join us for lunch, and then we do the program from 12:30 to 2 o'clock Eastern. We cover a very wide array of legal issues, and for those of you who have missed a number of our programs in the past but might be interested, we have all of those programs recorded and hosted on a special nonprofit YouTube channel that we created, and there's a link to that site, to that page on the last slide of today's PowerPoint presentation. A few logistical issues before we get into talking about our speakers and the topic here today. We do have a lot of material to cover today, and this always happens when we get into political and lobbying and election year related legal issues affecting nonprofits, in part because there's so many different areas of law that come into play. It's not just one statute or one set of regulations or one body of law. It's a wide variety of things that affect and regulate and dictate what nonprofits can do and can't do in the advocacy and political activity area. And so as such, there's always a ton of material to cover. We're going to really try to break it down for you, help make it easy to understand, cover a lot of the essential basics that you need to know, but also cover a lot of the new developments, and there have been plenty in this area. So bear with us. It is a bit of a dense presentation today, but I have no doubt you're going to find it very interesting and entertaining, and we will definitely save time at the end for questions. For those of you here in the room, there'll be folks with microphones walking around to pose your questions so everyone on the phone can hear them. Just please raise your hand and wait for the mic before you ask a question. And those of you on the webcast, please send your questions to me using the chat feature on the webcast software, and I will be sure to pose those to our speakers at the appropriate times. Feel free to send those questions throughout. I may interrupt the speakers at certain times to pose some of those questions, and otherwise save them to the end, for the end. Those of you here in D.C. have a bound booklet in front of you that has a printed copy of today's PowerPoint presentation, along with a number of ancillary articles that our speakers and others here at Venable have written on this and related topics, along with full speaker bios. Those of you on the webinar should have gotten a copy of the PowerPoint presentation emailed to you, and everyone tomorrow will get an email that has a link to the recording of today's program with a synced PowerPoint presentation, all of those articles and bios. Feel free to forward that email on to others, colleagues or others who you believe might benefit from that. We also have a wealth of additional material on this topic on our website. As many of you know, we maintain a pretty vast library of at least 750 or more articles and PowerPoint presentations on every conceivable nonprofit legal issue. They're searchable by topic area, and we have so many in the lobbying and political activity area that we have a topic area dedicated just to that. So if you want more articles and alerts and white papers and other things on these topics, feel free to check that out. The link is on the last slide of today's program. I want to give a special thanks and acknowledgement to Kelly Harris of our marketing staff. She's been our go-to marketing person for quite a while now. She's about to go out on maternity leave for a few months. She's going to be sorely missed. But Marianne, sitting next to her in the back of the room, is here to fill in for the next few months. I'm sure we will survive without Kelly, but I wanted to thank her for all her terrific work and hard efforts and wish her only the best as she gets ready to give birth to her first child. So with that, thank you. With that, I'm going to introduce our speakers. We have two terrific speakers here today. To my immediate right is Ron Jacobs, and to his right is Larry Norton. Ron and Larry are co-chairs of Venable's political law practice. Venable's political law practice, I've been here for actually 15 years this month, and I've really seen the practice grow significantly over the years, and really I give Ron so much of the credit for that, because he's been here for most of that time and has really been one of the key driving forces in helping to grow that practice. It's now become a very large, very nationally recognized practice, counseling both nonprofits and for-profits in every aspect of political law compliance. Both Ron and Larry have become very well-known, notable experts in the field, widely quoted by mainstream media, industry media, and others, and both work very regularly on a daily basis with hundreds of our nonprofit clients in all of these issues. And so their experiences and everything they're going to pass along to you today are informed by all of those experiences. Ron has kind of worked his way up here at Venable from being an associate to now partner, and has been a key member not only of our political law practice but also our nonprofit practice. He's been a key part of our nonprofit team and really takes a key lead role in a number of matters that are multidisciplinary and has a great grasp on all of the different legal issues that affect nonprofit organizations, and is an invaluable member of our team. Larry has been with us for a few years now. Larry is a former general counsel of the Federal Election Commission, has a very distinguished career in the political law area, also has done a lot of work with quite a number of nonprofit organizations, so understands all of the core political law-related legal issues, but also understands the unique applications and implications for nonprofits. He's been a terrific addition to Venable. He's a great guy. We love working with him, and he's going to have a lot to share with you here today. So with that, without any further ado, actually there is one more further ado. I need to give you a quick preview of our upcoming programs, and I don't think at any time we've ever had this many programs scheduled so far. We're actually scheduled all the way through September. Up on the screen now is a preview of our next two programs. You're going to have the privilege or bad luck, depending on how you look at it, to hear Ron again next month, who's going to join us for part of our panel we're doing entitled Surviving a Governmental Investigation Without a Black Eye, Key Legal, Communications, and Crisis Response Considerations for Nonprofits. It's a program where we're partnering with the Ogilvy firm, a very well-known PR and crisis response firm. Does a lot of work with nonprofit organizations in the area. They'll be here participating in that program with us. It's a really exciting program. We already have terrific registrations for that, and I have no doubt it's going to be quite a terrific program. On June 18th, as we typically do, probably about twice a year, we tend to cover employment-related topics for nonprofits because they are such important issues. They are some of the issues that vex and trouble nonprofits as much or more than anything else in the legal space. And to me, they're also some of the most interesting. They're rarely black and white, and we have some terrific lawyers in the area. Two of them are going to be speaking on performance management and discipline in nonprofits, common pitfalls, unique challenges, effective solutions on June 18th. Both of those programs you can register now on our website, and then the three following that, the registration is not yet available but will be soon. July 17th, Key Trademark and Copyright Rules for Nonprofits to Follow and Break. August 13th, Privacy and Data Security for Your Nonprofit, Understanding Your Legal Obligations and Insuring Against Risk. And on September 16th, What's Ahead for 2015, Preparing Your Nonprofit's Group Health Plan for the Employer Mandate. So as usual, we try to cover a diverse array of legal issues and hope you can join us for those programs. So with that, I'm going to turn it over to Ron Jacobs to get us started. Ron?
Great. Thanks, Jeff. So next month's topic is what happens if you don't listen today. So today we want to cover sort of four broad areas. We're going to talk about sort of the pieces of the puzzle. What are the different parts of your organizations, different organizations that you can create to engage in political activity? Then we'll talk about the tools of the trade, sort of the different things that you can do with each of those pieces. We'll talk about how they all fit together, the disclosure aspects of it, the governance aspects that come together. And then we'll wrap up with some of the trends and, as we call them, coming attractions of things that you'll find coming down the road. One of the things I want to kind of make clear and set out when we begin is that a lot of what we're going to talk about today will be sort of based on federal law. Federal law does not equal state law. We will talk about certain things under state law, particularly some of the state disclosure rules and things like that. But just keep in mind that if you're doing an activity, if we're talking about it at the federal level, there may be different rules that apply if you're dealing with a state legislature or a state governor or something like that. So what are the pieces of the puzzle that we're talking about here? And we've got it broken into sort of four main components. The first is the 501c4 or the 501c6. Depending on whether you're a social welfare organization or a trade or professional association. Then we have the 501c3, which either may be a related organization to one of those C4 or C6, or it may be its own organization separate and apart. Then we talk about the connected PAC that applies if you've got the C4 or the C6, or a super PAC, which may be something else. And so what are these different things we talk about? Well, the C4, the C6, and the C3s are fairly common for most people to understand what those are. They're the trade and professional associations, they're social welfare organizations. On the C3 side, it's the public charities. Typically, think of those as performing sort of education of the public. The connected PAC is known as a separate segregated fund. It's what, if you're a C4 or C6, you have is sort of your related PAC. It's used to make contributions to candidates or to fund independent expenditures, and we'll kind of talk about what all those things mean in a second. And then there's the sort of the more newfangled option is the super PAC that does independent expenditures, and we'll unpack that and what that means a little bit. So there's a lot of terms that I've already rattled off talking about what those organizations are, and we'll go through and sort of discuss it briefly before we set the stage for what we're for some of the different activities to engage in. So the first thing that comes up that we hear a lot about these days after the Supreme Court Citizens United decision a few years ago are independent expenditures. And so what is an independent expenditure? It's a communication to the public that expressly advocates the election or defeat of a clearly identified candidate. It's got to talk about, mention a candidate. It has to use words like vote for, vote against, support or oppose, or have no other reasonable meaning other than supporting or defeating a candidate. The key thing is the first part of the word independent. It cannot be done in coordination with a candidate or a candidate's agent. So that's what's important to keep in mind about an independent expenditure. The other piece we've talked about are contributions or direct contributions. These are either checks that go directly to the campaign usually from a PAC. In some states they can come from the corporate entity itself. They're in-kind services that are provided to organizations or to campaigns from organizations, or they're expenditures that are coordinated with the campaign. So if your organization says, hey, I want to help this candidate, let's talk to the candidate about what we can do, that expenditure of money becomes a coordinated expenditure or a direct or an in-kind contribution to the campaign. So the differences are here that a direct contribution, very highly regulated under the federal model, subject to contribution limits, prohibitions on sources. Corporations can't give direct contributions. No matter what you hear about corporations giving money in elections, they can't give money to candidates, political parties, or PACs in the federal system. A number of states they can, but not at the federal. Independent expenditures, on the other hand, are sort of seen as a little bit less regulated. There are no limits on how much can be given to fund an independent expenditure, and corporations can either pay for independent expenditures themselves, or they can contribute to independent expenditure committees or super PACs to fund those activities. Another term that we have to add in here, I blame Larry for, is when he was the general counsel at the Federal Election Commission. Actually, Congress gets the blame, but Larry implemented it all. Our electioneering communications. These were addressed in the McCain-Feingold law. The idea was the sham issue ads that people talked about. Call Congressman so-and-so and tell him to stop beating his wife. No real issue there, all about affecting the election. So what these are communications that occur either 30 or 60 days before a primary or a general election. No other time period are they electioneering communications. They have to be to radio, television, or cable. So newspaper ads, billboards, internet, not covered. They have to refer to a clearly identified candidate, and they have to be targeted to the relevant electorate. So that's an important component, is that if you had what would otherwise be an electioneering communication to a state where the candidate is not running, it wouldn't be an electioneering communication. So we'll talk about how these comes into play in a little while in terms of disclosure and funding and things like that.
I'm just going to jump in. There was there's not a whole lot of the McCain-Feingold law that's left, but one of the key provisions in the McCain-Feingold law was a ban on corporate funding of these so-called electioneering communications. The idea being that many of these ads that ran before the election, call and tell Senator so-and-so to stop doing something terrible, were just disguised issue ads, and they shouldn't be funded by corporations. Now, of course, the Supreme Court has decided in a series of decisions that corporations ought to be able to fund electioneering communications, and what's left is a disclosure statute.
now we need to pivot a little bit because as nonprofits, we're all dealing with not only the Federal Election Commission and the state election commissions, but also the IRS, of course, in your tax status. And so the other piece of this is campaign intervention, which is what the IRS uses to sort of to describe the political activity of 501c3s, C4s, or C6s and limit or prohibit that activity. And unlike sort of the electioneering communication definition that had all kinds of nice, neat prongs to it laid out in the regulations, even the express advocacy is fairly clear when it exists. The IRS uses a facts and circumstances test that is at best described as vague and amorphous. It looks at things like the timing of the communication. Is the communication made in October before an election, or is it made in January of a non-election year? What's the content of the message? And then what's sort of the background dynamics? Is it an issue that's important to the race? Is it something that's going to be voted on the House floor? All those factors make it very difficult to sort of know when you're intervening in a campaign. And a lot of when we talk about sort of the IRS's proposed rules for 501c4s, a lot of that was really extending the definition of what's included in the campaign activity definitions. And so we'll cover that at the end, but just keep that in mind that that's moving. And so to try and think about how all these pieces fit together, campaign intervention is sort of the big blob that it covers a lot of different activity. Within that, any express advocacy is going to be campaign intervention. Some electioneering communications will be campaign intervention, although others may not. And then even some issue advocacy will also fit within campaign intervention depending on when it's done and sort of the different factors that the IRS considers. The other sort of area we want to talk about is grassroots lobbying. And that this is when you talk to the public about contacting members of Congress to support legislation. The IRS definition is relatively narrow. It's really important for 501c3s, but it also applies in terms of C6s when you're dealing with determining how much of your members' dues are deductible for lobbying or not. Grassroots lobbying has to refer to specific legislation and have a call to action. Call your member of Congress, tell them to vote yes or no on this legislation. What's different here is that in many states there's also regulation of grassroots lobbying. It's usually done through the lobbying disclosure statutes, and it can require an organization that does no campaign activity, just grassroots lobbying, maybe not even direct lobbying, to register with the state, disclose how much they're spending on the grassroots lobbying. So it's important to keep that in mind as we talk about this. A lot of it's focused on the sort of the IRS component to it, but there is a state component as well.
And Ron, maybe if you don't mind me just interjecting for a second, just to help put some of this in context, because as you can probably gather already, there's lots of different buckets of defined activity, lots of different definitions, multiple definitions of some of the same things like lobbying. Even particular types of lobbying have different definitions for different laws and different purposes. Sometimes it's helpful just to keep in mind some overarching principles here. First off, when we talk about nonprofit organizations, we're generally talking about tax-exempt nonprofits, although there are a number of taxable nonprofits out there, some of whom are active in the political law space. And that's important to keep in mind. Just because someone's an entity is a nonprofit, if it's not tax-exempt, it's not going to be subject to any of those restrictions and prohibitions that come from the federal tax code. Assuming it is tax-exempt, then what restrictions and prohibitions apply to it? And we're going to get into kind of the specifics here. I'm not going to delve into the details, but it's important to understand that what category of tax-exempt organization will dictate what sorts of restrictions are imposed on it. 501c3 organizations, they have the most benefits that come with them, and as such, they have the most restrictions. Restrictions on lobbying activities, prohibitions on political campaign activities. 501c4s and C6s, no limitation on lobbying activities, some limitation on political campaign activities, as Ron's going to get into. And for 501c3s, you have this limitation on lobbying that includes both direct lobbying and kind of a sublimit in certain cases on grassroots lobbying. Then these same definitions, though, are also important for other laws like the federal lobbying disclosure law and state lobbying disclosure laws, none of which in any way limit lobbying, but do require you in many cases to track lobbying and to report it. And so that's one of the reasons why this area is so challenging. And this setting the stage slide and there's other categories of exempt organizations too, like super PACs and PACs under Section 527 and whatnot, that also come into play. But it's important when you're thinking about these things or trying to figure out what definitions apply or for what purposes to put things in the proper buckets. And that's going to help you figure out, once you figure out what bucket you get it into, then you can figure out what sort of activities are involved. And if you're going to reverse engineering it and you're an organization, you want to engage in certain activities, but you think you might have some restrictions based on the tax code or the federal election laws or anything else, then you kind of reverse engineer it by saying, okay, what are the options, what are the pros and cons, limitations, or not of engaging in various activities based on the type of organization, and then work from there.
And the other piece I would add to sort of the limits are also on the aspect of disclosure, because what you are depends on how you disclose, where you disclose, and what you're doing affects that as well. So the same activity conducted by two different organizations may be disclosed differently, which may be very important to your donors, or it may be important to the organization. So it's important to keep that in mind as well. And the final piece to think about with putting things in the buckets, it's very important, as Jeff said, to get the buckets right. But what's interesting is that there's often a lot of overlap in between sort of when you're lobbying, when you're engaged in issue advocacy, and when you're engaged in campaign intervention can very easily move between. Changing a word or two in a message can move you into an entirely different bucket. So it's very important to get the sort of the scripts right to understand. We've had clients where they have a C3 and a C4. They have a particular message. A little bit of wordsmithing means that the C3 that has a lot more money because the contributions are deductible can deliver that message and pay for it. If it's phrased a little bit differently, the C4 could only pay for it and not the C3 because it would be considered campaign intervention. So there are very fine lines and a lot of overlap between the two. So that
and just to put one point on something Ron touched on a minute ago, really important we've seen in recent years, the issue of disclosure sometimes is even more important to a lot of organizations and their donors than tax benefits or tax limitations. And that's why we're seeing even now the taxable nonprofits and other entities come into play where donors are so, what's most important to them is keeping their identities confidential. And that's where you really need to understand to what sort of entity can you make donations, and those donor names do not have to be disclosed, and when do they have to disclose. There's always going to be trade-offs in terms of taxability, tax restrictions, things like that. But that's definitely been a trend that we've seen in recent years where disclosure and confidentiality of donors' identities is an equally important driving considerations to tax benefits and other things.
Absolutely. So with that stage set for sort of the different terms, the different kinds of organizations, the general do's and don'ts, I'll turn it over to Larry to start talking about some of the specific tools, the things that you can do to engage in sort of electoral or lobbying activities.
Well, thank you, Ron. And first thing that I want to talk about are PACs, political action committees, that many of you may be familiar with because 501c4s and 501c6 trade associations commonly form PACs that are connected to their organization. And the reason that you have to do that is because, at least under federal law, a corporation still may not make a direct or in-kind contribution to a candidate. The only way for an incorporated entity to, or not the only way, but the only way to make contributions to a candidate is by the creation of a PAC, or political action committee. And it's funded not by the incorporated entity, but by contributions by individuals. And we'll talk about in a moment about who those individuals are who can give to a PAC. As Jeff mentioned earlier, it's important to keep track of what kind of tax-exempt organization you are. And with PACs, it's important to remember that the PAC itself is its own tax-exempt entity. It's tax-exempt under Section 527 of the Internal Revenue Code as a political organization, meaning that's its primary activity. And so its receipts are non-taxable. And the 501c4 or 501c6 organization establishes this separate tax-exempt that is appended essentially to it, the 501c4 or c6.
I think what a PAC is under corporate law is one of the most metaphysical difficulties to envision, because it's usually not separately incorporated. It's, as Larry said, part of the organization. It's in essence a separate bank account that has its own tax status. And one of the things that everyone needs to remember is that if you create a PAC, it should have a separate taxpayer identification number. It's very important that it doesn't share the 501c4 or the C6's employer identification number.
Yeah, it is an unusual creature because while legally it is a separate organization, it's very rare that a PAC has its own employees because it's managed by the association. Its administrative expenses are paid for by the connected organization or by the association. It rarely has any assets, frankly, other than the bank account. So who can fund a connected PAC? There are a few categories here where the PAC can sort of reach out for funding. The first category are its individual, its non-corporate members. And to qualify under the FEC rules, Federal Election Commission rules, as a member who may be solicited by a trade association PAC, you have to satisfy whatever criteria have been established by the organization for membership in your own individual capacity. And you either have to pay dues at least annually or participate directly in governance of the organization, and often because you have voting rights. So those individual members may be solicited for PAC contributions. Association executives may also be solicited if they're salaried, they're in a position of management, supervising, helping run the organization, or they're members of what the FEC calls the recognized professions, like lawyers and accountants and engineers and so on. What you have to be careful about sometimes here is that if you have an individual who is sitting, let's say, on your board, on the PAC board, but that person's dues are paid for by his corporate employer, and he's designated for individual membership by the employer. So while that person is obviously an individual, they don't have any individual membership rights. Their entire participation in the association or in the PAC is as a representative of its corporation. That individual would not qualify as a member under FEC rules and could not be solicited by the PAC on that basis.
Which I think, Larry, would differ if it were an individual member whose company had paid the membership dues. The important distinction is sort of that representative versus sort of just the company paying for it.
Maybe we should just clarify, too, when we're talking about individual members, Larry's talking about particular human beings, individuals, like a professional association, a professional society where the members are individuals. So the basic rule is that you can solicit a connected PAC or an association that has a connected PAC. The association is actually the one that's allowed to pay for the cost of soliciting the members. It can pay for the cost of running the PAC and the cost for soliciting the members for contributions, the actual campaign contributions that come from the donations themselves. But if it's individuals, if they're bona fide members that meet the test that Larry described, the Federal Election Commission created, then you can solicit those individual members, those individual people. If they're corporate members, then Larry's going to get into under what conditions can you solicit individuals that work at or employees of or shareholders of the corporate members of the association. And there a whole different set of rules comes into play that Larry's going to talk about.
Right, so that's the last group. So you've got your individual human being members, you have your association executives, and then there is an opportunity for the association to solicit certain employees of its corporate members. But those individuals who may be solicited from the corporation also have to be in this so-called restricted class. So it's your executives and your lawyers and accountants and engineers, the ones who are running the business, and only they who may be solicited by the trade association PAC. And not only is there a limit on who you can solicit from the corporate member, but before you do any solicitation, you must request and receive the corporation's permission to solicit. There's a prior approval process where the trade association provides the corporation with a form to sign off. You have to sign off for each year. There's a strange FEC rule that limits corporations to allowing only one trade association per year to solicit from its restricted class. The request to solicit may include a solicitation along with it, but it's only a sample or example of a fundraiser at that point, fundraising solicitation. Until the corporation has signed off and said, yes, we haven't granted this authority to any other trade association. You have authority to solicit our corporate members or some of our corporate members. only then can an actual request be made of the executives of that corporation to contribute.
I think prior approval is probably one of the more complex areas. It stymies a lot of organizations because getting the prior approval is very tricky. We're going to talk about some ways to make it successful, but it's one that people will say, you know, we've got this PAC, we're all set to go, we've rolled out the communications plan, and then they say, oh, but we don't have prior approval, so we can't communicate with any of those people.
They are really arcane rules. Ron and I talk all the time about whether they could be sustained in light of some of the more recent Supreme Court cases, but the Federal Election Commission has not undertaken any sort of rulemaking to revisit these procedures. So they're still there. It is complicated, and I think the best overarching advice that's suggested by the slide that's in front of you now is to really keep the request as simple as possible. It's not about fundraising. You're not asking for money. What you're really doing is asking if you can ask. You're asking for approval to solicit, and then once you have that, you can work with the corporation as to whether it's comfortable having the trade association solicit directly, whether it wants to be the one to ask the employees or both, and which employees and how often and all those sorts of things. Next slide is what is a solicitation, which again is one of those, well, of course, it's when you ask for money, but not in FEC parlance. A solicitation in the view of the FEC is anything that you communicate that could encourage someone to contribute. So even if there's a newsletter that goes out from the association and it says, we really want to thank all the folks who contributed to the PAC last month. It was really a terrific fundraising drive. You're really helping us do some important things through our PAC. The FEC has said that that kind of communication that doesn't include any explicit ask is still a solicitation for purposes of federal campaign finance law. Now, why does it matter? It matters for a few reasons. One is, if it's a solicitation, you need to be careful that it's not reaching individuals who are outside of those groups we talked about earlier, the executives of the association, your individual members, and certain employees of your corporate members. Anything that's a solicitation has to include what the FEC calls a disclaimer, so language about how it's voluntary and it won't affect your employment, and if there's a level of contribution suggested that it's merely a suggestion, that the contribution to a PAC is not tax deductible. All those things need to be in any communication, whether it's email or mail or what have you, if it constitutes a solicitation. Sure.
Wait, hold on. Kelly, we're going to quickly bring a microphone up. No, it's okay. We do want to save most questions for the end, but if anyone does have a burning question in the middle, don't hesitate to interrupt.
The class that you can solicit, you said it was the executive leaders. Does that include the board members of that corporation?
No, not necessarily. The FEC rule, and FEC sort of has its own rules about members of the board. It may include the board members if they are also individual members. In other words, satisfy pay.
Do you mean the board members of the company, or the board of the member company, or the board members of the association?
Okay, so
you're asking if there are board members of the member company, are they part of the class that is able to be solicited, presuming there's prior approval?
So the FEC rule about soliciting board members of the member company are that the board member must be paid a stipend or fee for serving as board member. So if you have a volunteer board without any reasonable stipend or fee paid for board service, then that person is not considered part of the restricted class. If you have that stipend or fee, then they are. This is a key slide, the PAC administrative costs that Jeff touched on earlier, and it really makes PACs such a value. The reason that PACs are a great value is it's obviously challenging to raise money when you're only limited to individuals and from other PACs. But the upside is that you really should have no overhead. All the administrative costs, all the costs associated with running the PAC can be paid for by the connected organization, either the 501c4 or the 501c6. So that includes bank fees. We recommend that you talk to your bank, and if their fee is going to be charged, you arrange that those fees are charged directly to the trade association and not to the PAC. Postage, delivery services. If someone is attending a fundraiser and delivering a PAC check from your association. The association itself can pay for the cab fare, can pay for hotel or airfare if you're actually traveling to a fundraiser. If you want to have a lunch or breakfast to sort of roll out, announce the PAC, that's a fundraising cost. That can be picked up by the trade association, and subject near and dear to our hearts, compliance, legal fees, all that can come out of the connected organization. So it's really true that almost dollar for dollar, your PAC funds ought to be used for the purpose that someone is intending them for, which is to support candidates. There are all sorts of ways that PACs, that associations and C4 groups can incentivize individuals to contribute to the PAC, inducements, some of them listed here, like drawings for prizes, trinkets, charitable matches, entertainment other than food. The FEC has this peculiar thing called a 1/3 rule, which in a nutshell means that if one of your corporate members or your association is providing a prize of some kind, an inducement, the value of that cannot be greater than 1/3 of the amount of money that you raise by virtue of the prize. So the FEC gives an example of somebody goes out and you buy an iPad and you have a raffle, and the iPad costs you $700, and you raise $1,200, let's say, in contributions because you're giving away this iPad through the raffle. Well, the FEC would say that in that case, the 1/3 of the amount that you raised is only $400. The value of the prize is greater than 1/3 of the amount you raised. And the way you cure that is the PAC literally has to give $300 back to the corporation to make up the difference between 1/3 of the amount raised and the value of the iPad. So the idea is that a corporation or an incorporated trade association shouldn't be able to circulate funds and essentially give to its own PAC.
One of the ways to sort of balance that out is to think about how you frame the time period for the raffle. So if you were to give an iPad out to everyone who contributes during the course of the year, presumably that's to be a much higher amount than if we did a PAC fundraiser here in this room and said, everyone who contributes today during lunch can get the raffle. So that's one of the ways to try and balance that 1/3 out.
There is this concept under the law called a non-connected PAC, which some of our clients have. A non-connected PAC may not be supported, may not have its administrative costs paid for by another organization like a connected PAC. So why would an organization, why would a trade association or 501c4 have a non-connected PAC? Well, because it has no members from which to solicit, and perhaps it wants to be able to solicit more broadly outside of those categories we talked about earlier. And a non-connected PAC may solicit from any individual who is a U.S. citizen, regardless of whether they're a member or part of the restricted class of an organization. Of course, the trade-off there is that all those costs need to come out of the PAC itself. And if you're not, if it's a PAC that's not raising a lot of money, those costs can quickly cannibalize the receipts that the PAC wants to use to make contributions.
Another time where we see a non-connected PAC sometimes is a 501c3 is not allowed to have a connected PAC because of the prohibition on campaign intervention. So sometimes executives or board members that are involved with the C3 on their own time, not using any C3 resources, will create a non-connected PAC that has a similar mission to the C3, being very careful again not to use the resources of the C3, but that PAC can then contribute to candidates that are helpful in sort of the legislative issues that the C3 is involved with. But again, you've got to be very careful that it's completely separate in that situation.
We're going to leave PACs for the moment and jump on to the second big item.
One quick question from the webinar, which is a question that we do receive sometimes, so I think it's worth interrupting for this. One of our participants says, is there a limit on who can contribute to a connected PAC as opposed to who can be solicited by the PAC? So we've talked about the limitations on solicitation. If you had an unsolicited contribution, is there any limitation on from whom individual or entity you can take such a contribution?
Any PAC may accept any connected PAC may accept an unsolicited contribution from any individual who's eligible to make a contribution, which for a federal election means someone who's a U.S. citizen or a green card holder. But unsolicited truly means unsolicited. If the FEC has said that if the PAC or the organization communicates to some individual that the PAC may accept unsolicited contributions and then receives a contribution from that person, that's not considered unsolicited. So it truly is the contribution that comes out of the blue, out of the good graces of someone's heart. They happen to know you have a PAC, and you've really never talked about it or suggested in any way that it's there in case they wanted to part with some of their money.
For example, a website that's unrestricted, meaning that if anyone can go to the website and make a contribution, that would be a solicited contribution. You can't just sort of stumble upon, even if you stumble upon the website, the donation mechanism itself would be a solicitation. So it really is sort of the check that gets mailed in from a random person who's never been asked or heard about the PAC or seen requests for the PAC contribution.
So jumping from PACs to the next thing in the toolbox is hosting fundraisers. And there's a couple of categories we quickly want to touch on here. One is the fundraiser where the only people you invite are members of the restricted class, so your executives, your professionals. And that kind of fundraiser held for a candidate may be hosted by the association and paid for by the association, so long as the only people there attending the event, other than the candidate, are individuals who are either in the restricted class, a few individuals, if necessary, who may not be in the restricted class but are there to help administer the event, check in people who come in, take coats, that sort of thing, plus guests who are speaking or being honored at the event. So the concept is maybe a couple of other people are there. The representatives of the association may suggest to attendees, either before or during the event, that they contribute to the candidate, although they're not supposed to handle the checks. The check should be sent right to the campaign. The idea is that handling the checks is a kind of corporate facilitation that the FEC views as prohibited. And finally, there's a note there, for the most part, the costs of corporate internal communications are generally not reported to the FEC. But if you have a communication that's primarily devoted to express advocacy and it costs more than $2,000, you're supposed to file a report with the Federal Election Commission. Rarely happens, and frankly, when it happens, I think it's rarely done, but the rule is still there. Different rules if you're an association and you want to host a fundraiser or you want to invite people outside of the restricted class. So you want to invite your lobbyists and your friends and others to really fill the room. In that case, the trade association itself may not fund the fundraiser. The funding has to come from a permissible source, which could be your PAC. It could be individuals any individuals who are associated with your organization, and in many cases it can be the candidate himself or herself. Remember, if the costs for a fundraiser are paid for by a PAC or by individuals, those are considered in-kind contributions. They apply to the PAC's limit or the individual's limit. They have to be reported by the candidate. And the last slide here is hosting fundraisers that are personal events. These are the ones that are literally held at your home or the home of the CEO of the organization. Any individuals can be invited. The FEC provides a sort of write-off, an exemption from the contribution rules of $1,000 per person per candidate. So you can spend some money on food and beverages without having that considered an in-kind contribution, but everything after that is treated as an in-kind. The one area where we get questions all the time and is a real area of risk is the event that's held in someone's home. It's a personal event, but you've got the executive assistant who is handling the event soup to nuts, who has prepared the invitations, who sent them out, who is handling the RSVPs. Those kinds of seemingly minor activities by a corporate employee is considered corporate facilitation and an in-kind contribution by the association and in violation of the ban on corporate contributions. And this is a hard message sometimes for us to convey, because at the most senior levels, you're talking about people who have assistants who often take care of every facet of their lives, but they can't do this unless they're compensated for it separately from the compensation they receive from the association or the corporation. The FTC used to be very aggressive about going after these cases, has been less so over the last few years, but it's an area where we suggest because of reputational and other risks that it's something you ought to be careful about.
We've had examples where during the presidential election, CEOs of large companies have been working on fundraisers, and their support staff typically do everything for events that they host. So even in that scenario, the value of the labor from their assistants would be greater than their personal contribution limit to the candidate. So the CEO can't just pay the staff to do the work. So we've had situations where the campaigns have paid the companies to take care of the labor costs for doing that fundraising work by the support staff. So it's something that candidates are used to and understand the need to take care of these issues. The next area we want to touch on sort of turns a little bit and pivots to what we describe as public communications. So these are going to be messages that your organization or one of your pieces of the organization pay for to reach out to members of the public. And the key here is that these are things that's on your website, they're television ads, radio ads, mail, email, social media, whatever it may be, where you're broadcasting a message to the public that fits into one of the buckets we talked about before. And so the key here is that in general you're going to be allowed to do this without much limit, unless it's a 501c3 where you have a limit on the amount that's spent for a grassroots lobbying communication, or if it's a C3, it can't engage in campaign intervention. So the point with the public communications, the first piece is that you have to determine what it is so that you know which bucket it fits into, and then determine which limits apply and whether you're going to be disclosing the entities that contribute to it. So if it's a issue advertising, in general, you're not going to have a lot of disclosure that's required for that. Whether if it's going to be a lobbying communication, again, you can do it. There's just going to be various limits on who does it. Express advocacy, electioneering communications, again, allowed to do it, but there will be the disclosure issues. And so we want to talk a little bit about sort of what those disclosures are and how that comes into play.
Disclosure is really the name of the game right now in this area, and it's particularly become the source of focus because so much other activity has been deregulated. But it's important to remember that 501c4s, 501c6s, and even 501c3s have to worry about some of these disclosure laws. It's easy to sort of assume that a 501c3 charity that's prohibited from engaging in electoral activity under the IRS rules couldn't make an electioneering communications for purposes of the Federal Election Commission rules, but it happens all the time. If you're running an ad and the ad is to promote reading, and you've got the congressman, sitting in a classroom with a bunch of school kids, and the message is, spend time teaching your kids to read. That ad runs in the congressman's district. It's within 60 days of the general election. That's an electioneering communication, and it requires a disclosure report with the FEC. There are all sorts of requirements, federal and state, that require paid-for-by statements on ads and other kinds of written communications. The FCC has what it calls sponsorship ID rules. It requires a paid-for-by statement, not just on candidate-related ads, but in the FEC's rule, any controversial issue of public importance, which I would guess probably, whatever it means, it probably covers a lot of what folks here are doing every day. And then, of course, there are lots of requirements at the states where grassroots lobbying is regulated. Political ads sometimes trigger reporting and registration before the ads can be run. Patch-through calls that you might be arranging, patch-through calls to the state legislators, often require certain disclosures or disclaimers or registration associated with that. So it's an area of tremendous ferment in terms of regulation and a lot of things to pay attention to.
And keep in mind that in terms of tracking these sorts of expenditures and activities and reporting them and disclosing them, many times, as you can probably already gather from today's discussion, you're going to have to do this using different definitions, different tracking, different disclosure, different reporting to different agencies for different purposes. Even entities like 501c6s and C4s that are not at all limited in how much lobbying they can do, 501c6s in particular, it's very important under federal tax law to track lobbying expenses because there is a real financial implication there because of the law that Congress passed back in '93 that requires trade and professional associations to track their lobbying expenses and then inform members that pay membership dues to the association that their members' dues are non-deductible as a business expense to the extent that they engage in lobbying in political activity. And so it's important to keep all of those things in mind. That has very significant, sometimes financial implications on the members in terms of membership dues, non-deductibility for federal and state tax purposes. So don't forget about those issues when we're talking about disclosure and reporting as well.
Next item on our bucket is communication to members. The general rule to remember here is that a corporation or an incorporated trade association or 501c4 is free to communicate with its restricted class, again, those executives and professionals, on any subject. That includes suggesting that they make political contributions. And that message may be coordinated with a candidate if the association is planning an event where only restricted class are going to be appearing. So candidates coming to visit the office, there's going to be, it's a fundraiser, it's also a meet and greet, you're only going to have the restricted class there. The association itself can coordinate with the candidate regarding the message that's communicated at that event. Be careful though, because the FEC may view that permissible coordination as compromising the independence of later communications by the corporation or the PAC that it's not entitled to make, the kind of public communications that Ron was talking about. So we've got a slide here on grassroots lobbying. The point we really wanted to make here is that if you're a 501c3 organization and you're communicating with your own members about legislation, remember that's considered direct lobbying if you're communicating with your own members, not grassroots lobbying. Why is that important? Because as a 501c3, you're limited generally in terms of how much lobbying you can do, but you're especially limited in terms of how much grassroots lobbying you can do. So there's more latitude, more flexibility to spend money in connection with communicating with your own members. So next up on the tool box is voter registration and education. And there are, again, different rules for different kinds of organizations. Important to remember here that this is largely regulated by the IRS. The rules here are that if you're a 501c3 or 501c4 organization, or 501c3 organization, your voter education and your voter registration must be nonpartisan. Nonpartisan, under the IRS rules, has a special meaning, and is a special meaning in the tax code, which means that you cannot intervene on behalf of or in opposition to a candidate for public office. So if you're doing voter education, it's really got to be designed solely to educate. And if you're doing GOTV, it really has to be to encourage people to exercise their right to vote, not to teach them or suggest how they should vote. If you're a 501c4, you can do a certain amount of partisan voter registration and education. It can't be your primary purpose, and PACs and super PACs can do an unlimited amount of that. Quick point before we leave this area, it doesn't do any good to segregate your activities into sort of nominally separate C3 and C4 organizations if the educational effort of the C3 is part of a unified effort to do electioneering by the C4. The IRS, as they do in other contexts, really looks through corporate formalities to what's really going on. And if you're going to use a 501c3 to educate voters about an issue, to get voters to pledge that they're going to commit to take into account an issue, to register to vote, all of that activity not only has to be nonpartisan, but it can't be part and parcel of a larger effort by a connected C4 to get people to vote for a particular candidate or to target particular jurisdictions. So a lot of care has to be exercised on the C3 side for this kind of activity.
You know, we could spend an entire program, we could spend an entire day talking about the rules about how affiliated nonprofits can and cannot affiliate, what sorts of walls need to be set up between connected, related affiliated 501c3s and C4s, or C3s and C6s and PACs. A lot of it has to do with money flow. You can't be using, for instance, money from the C3 to in any way directly or indirectly support financially or otherwise the activities of the connected C4 or C6. or a PAC that might be then connected to the C4 or C6, which itself is affiliated with the C3. There's also a lot of issues and rules and considerations that come into play with respect to governance and overlapping boards, contractual relations between them, flow of services and staff and money, and all of that is very, very important. We actually did one of our programs about 2 years ago on the subject of kind of subsidiaries and affiliates, which you might want to listen to on our website. But keep in mind that's a whole area that we don't have time to get into in and of itself, but it's an area that the IRS and others are very, very much focused on, and you have to be extremely careful if you have affiliated entities to keep them truly as separate and independent as possible.
Another activity that a lot of organizations like to engage in, whether it be for sort of lobbying or for campaign purposes, is to have candidates appear to talk to their members, to talk to their employees. And there are a couple different rules that come into play depending on what's going on. One of the easiest ways to have an event like that, the person may be a candidate, but to invite them in their official capacity. So a member of Congress who's sitting for re-election that you'd like to introduce to your association, to have speak to the board of directors or to the members, rather than do it as a campaign event, do it as an official event so that the member of Congress comes there. It's scheduled through their official office. They talk about issues. The key is they don't talk about their election. The reason this is easier is that you avoid having to deal with issues about whether it's a restricted class, who's paying for it, all the campaign finance rules that come into play. You can also, if you're doing a broad audience where if it were a candidate, you might have to invite both candidates. If you're inviting the sitting member of Congress, you can just invite the sitting member of Congress and they can talk about it and accomplish much of what you would otherwise accomplish if it were a campaign event. Another way to do it is to set up a debate format or a candidate forum. Here, even a C3 can do these kind of events. The key for debates, for nonpartisan events, is that you invite all the candidates. The questions, though, have to be nonpartisan, so you can't ask a candidate to commit to supporting a particular position that your organization favors. You can't ask the questions or comment upon the questions if you don't like the candidate's answers. You have to provide equal time. This is important, particularly if you're doing a candidate forum, maybe where one candidate is going to address the organization and then the next. They have to have sort of equal opportunities. The FEC has said you can't give one person the noon lunch slot and another person the 8:30 in the evening slot when everyone's left for the day. Another way to do it is to actually do the candidate appearance if you're interested in having the actual candidates there. Many of these are structured in sort of the fundraising bucket that we talked about a little bit before. But if you're doing it in general with your restricted class, you have a lot more options. So again, the executives of the association, individual members, if you have individual members, the corporate member, you can communicate with the person you normally communicate with about these things. So you can have a restricted class appearance where either the association or the candidate ask for the vote. They appear in their candidate with their candidate hat on. You can ask for contributions. And the other thing is you can do it with only one candidate. You don't have to ask everyone to attend. On the other hand, if you're doing a candidate type event where it's outside of the restricted class and you're having the candidates there, then much like the debates, you have to have all the candidates there, give them equal opportunity, and there's no opportunity to solicit contributions from those in attendance at those kind of events.
Real quickly, as Jeff said, this is another topic we could spend an awful lot of time on, but we're going to touch on it just very briefly here, just to say that if your organization is paying for travel, official-related travel of a member of Congress or a executive branch official, there are specific rules that govern when and what kind of travel you can pay for. Much stricter rules apply to organizations that either employ or hire an outside federal lobbyist, limits on the length of the trip and what can be provided, different rules, as is the case with gift rules generally. There are different rules on the House and the Senate side. So you'll notice here there's a reference to the one-day trips. On the Senate side, a 501c3 group is exempt from that rule. And the biggest point I would say as a takeaway on travel is allow plenty of time. If you want to pay for a member of Congress or an executive branch official to come and address your annual event, there's a process. There are papers that have to be submitted by the sponsoring organization to the ethics committee that take some time to go through. Be surprised at the kinds of questions that come up. But if you don't allow, at least, several weeks or longer to work through that process, you can find yourself without a member.
We had an interesting situation this winter and learned that the Senate only approves trips by regular mail. So the Ethics Committee had approved a trip. It was an association that was taking staff up to New York, and everyone had received sort of unofficial word that the trip had been approved, but it was a snow day, one of our many snow days, and no one had their letters in hand. So fortunately, the Senate Ethics Committee staff was very helpful. I was able to track the person down by their cell phone. The person couldn't email me any approval, but she said if any of the people who want to attend the trip wanted to call her, she would be happy to tell them that they had been approved. She wouldn't email me the list because it had to be in writing. So everyone called from Union Station because the fellow was waiting to leave. They each called her in turn. She gave them their blessing. They went and they had a great trip. As I understand, it was very educational and informative for them. But so good example of why you need to make sure you leave plenty of that time for the travel.
And before we move on, one quick aside, and we have spent some of our monthly programs focused on the lobbying rules, not only the tax stuff, but the last slide referred to the LDA. That's the Federal Lobbying Disclosure Act, a law that's been around since '95 that many of you are probably very familiar with. I'm not going to get into the details on that, although I will point you to a number of resources, both recorded webinars and articles and whatnot, on our website that explain all of the rules in this area, when you have to register and then do subsequent reporting on Capitol Hill, both with the House and the Senate, and when you don't. And as Larry and Ron alluded to, congressional gift and ethics rules kick in different ways, whether we're talking about a registered lobbyist or not. And by lobbyists, we mean both individuals and organizations. And organizations are required to register both when they have employees who do certain amounts of and certain types of lobbying that can trigger the registration requirement for the entity, and also when you retain outside lobbyists. Both come into play. Again, that's a whole area in and of itself, very complicated rules, but just be cognizant of the fact that if your organization or you individually are a registered lobbyist, then that's going to have implications for gift and ethics rules and other things as well.
So just to quickly pull this together, and I think Jeff has made some observations along the way that touch on some of these things we were going to talk about here. First off is disclosure. Again, lots of disclosure laws, federal, state, and local. Tax IRS requirements regarding lobbying that must be disclosed, activity that must be disclosed in the annual information return, the Form 990. States have their own laws that regulate lobbying, require registration and disclosure. Gifts may have to be disclosed either by lobbying organizations or simply by any individual or other organization that provides what's considered a gift to an official. There's the Federal Lobbying Disclosure Act that regulates an awful lot of activity. And as Ron noted earlier, there's a lot of overlay here. There's lots of disclosure, of course, under campaign finance laws, federal and state, and lots of information, by the way, available about what your organization is doing, what gifts it has provided, how much it's spending on lobbying, who it's hiring, and of course, the same information is available to you about other organizations that might be interesting and useful.
One of the things we talked about a little bit is we figure out how you put the different pieces together as the members. And one of the things where this is really important is, as Larry talked about, the PAC. So that if you have a 501c3 that has an affiliated C4 or C6, an issue we've seen come up is that a lot of times those are structured so that the sole member of the C3 is the C4 or the C6. Well, that means that the sole member of the C4 or the C6 is the C3. Well, that means there's no one that the C4 can solicit. You've created this whole new wing to do all of your lobbying and your political activity, but there's no one that you can solicit. So it's important to remember as you develop your structure to think about making sure that if a person has joined the C3, do they automatically join the C4 or the C6, or is it a separate membership process? How do you make sure that it all flows together so that you actually have a restricted class to solicit for your members? As Jeff alluded to, there's a lot of issues about board overlap and how the boards are structured. One of the key things is that there can be some overlap, but they're not going to be all the same people. When you're conducting board meetings, you want to make sure that you have your folks wearing the right hats, that you have your C3 board meeting You stop the meeting, it ends, the new people come in. If some people maybe move over to shift seats, you have your C4 meeting. The super PAC, the same thing. So it's very important to make sure you've got that structured, that you observe all the corporate formalities, and that you make sure that you're not using the C3 for the wrong purpose. The IRS looks at these things. There are audits in particular. The board, the neat and tidy minutes that you keep are going to be very important.
And if there's one thing to focus on the most above everything else in this area in terms of affiliated entities that are going to have some overlap, obviously there's going to be close connectivity between them. There's obviously always going to be some level of coordination, even though technically there shouldn't be. But the most important thing above everything else to keep in mind is the money flow. Who's paying for what? Who's supporting what? And above everything else, if I had to pick one thing that matters most, that's what matters most. And what we're talking about is, of course, when you have a C3 and then a C4 or a C3 with an affiliated C6, which might then have a PAC or a super PAC, money going from the C3 to any of those other entities is what is prohibited. That's what you have to focus on the most. It's generally perfectly acceptable for a C4 or a C6 to provide support, free staff, free office space, etc. for a connected C3, but not the other way around. And so you need to make sure if you have that affiliated entity structure that the C3 is not in any way directly or indirectly subsidizing financially those other entities.
Another issue that comes up is how the boards are appointed and how you develop the right level of control. So there's different options in terms of whether one board appoints another, whether the members appoint the boards, but you want to do it in a way that the organizations are separate and distinct, yet avoid the situation where the C4 suddenly runs off and does something that's counter to what the C3 wants because the boards are completely independent of one another. Perhaps if they're self-perpetuating boards, then over time they can grow apart and you can have the groups working at cross purpose. So make sure that you structure them in the right way, that they're separate enough for the IRS, but not too separate that they go off the reservation and do their own thing.
I think Jeff has really covered this point. The important thing is Jeff was mentioning is that the 501c3 can't engage in any political activity, any electoral activity at all. It's limited in the amount of lobbying it can do. And the way that you protect yourself is to make sure that the C4 or the C6 pays at least its full share of employee salaries, of equipment costs, and rent for running the day-to-day operations. And you do that through cost-sharing agreements and other arrangements, literally arm's-length arrangements between the organizations. Same thing on the management side. There need to be, where even if you have closely related C3, C4, C6, there need to be separate programs and budgets. If it all looks like one big happy organization with no observance of corporate formality, the IRS may impute the political activity or the lobbying activity of a C4 or a C6 to the 501c3. If it's political activity, it could be fatal to its exemption. It has liability implications if the organizations don't operate separately. So in every respect, management, employees, things need to be kept separate.
Another area where separateness is important, even within an organization, can be if you're doing independent expenditures, whether through a related super PAC or directly through the C4 or C6, or from a regular PAC, because traditional PACs can also do independent expenditures. And the issue here is that in order to avoid coordination, you may have employees who interact very regularly with the candidates. If you have a good lobbying operation where they're meeting with the candidates, they're talking to them, they understand what's going on, or you're sitting down for fundraisers, supporting candidates with direct contributions, then you're going to need to come up with a little firewall arrangement so that there's a separation of the employees who are doing the independent expenditures. Otherwise, there can be allegations that the independent expenditures were actually coordinated and then it would be in-kind contributions. So internal procedures there, even within the organization, can be very important. I think we've talked about the various payments and what the C3 can and can't do and the C4 can and can't do.
And one thing, Ron, there was an interesting IRS revenue ruling a few years ago that stressed the point that it's not just direct money flow between, say, an affiliated C3 and C4, but that ruling related to website separation, and the IRS held that there wasn't enough separation on the websites and the way that they connected between the two, between the C3 and the C4, and that proved to be fatal for the exempt status of the C3. So it's even in that area, the IRS is very much focused on that. And in an election year like this, what we see is that the IRS, not surprisingly, tends to really crack down and put special emphasis and focus in this area.
And the same thing with the fundraising. It depends on who's paying for the fundraising. The C3 can't resources can't be used to raise money for the other organizations and vice versa, so that fits together. As well as the intellectual property. You make sure that you've got the licenses in the right spot, make sure the IP resides in the right organization to avoid that the C3 money flowing to the C4 or the C6 money flowing to a super PAC without disclosure. Those kind of things are very important. So what's ahead? What are we thinking about are the new trends in enforcement and disclosure and things like that?
Well, it's still true that the Supreme Court as currently composed has yet to meet a campaign finance regulation it likes, and recently had yet another campaign finance case before it, the McCutcheon versus Federal Election Commission. And the court, by another 5-4 majority, which seems to characterize every major campaign finance case for over a decade, decided that the FEC's ban on the overall amount of contributions that an individual can make to candidates and to PACs and to political parties was unconstitutional. That in the view of the majority of the court, there's no corruption threat in allowing an individual to make unlimited contributions subject to the base limits. That is the limit on a contribution to a particular PAC or a particular candidate. As Ron and I have been saying for some time, I'm not going to go into great details about McCutcheon, but I think really the biggest import of McCutcheon is its impact on state laws, well, both on the national political parties and on the state laws. The national parties, I think, feel that the McCutcheon decision will allow them to raise an awful lot more money than they were allowed to raise under the aggregate limits because those contribution limits were set pretty high to the national parties. The problem is that individuals would max out very quickly on their aggregate limits. With the aggregate limit gone, the parties feel like they can compete a little better with the super PACs. I think on the state level, though, this is going to have enormous ramifications. In nearby Maryland, where the state has a $10,000 limit on the total contributions an individual or a corporation, corporations can make contributions in Maryland, could give to all candidates and all PACs and all parties over a 4-year period, that's not very high. You could give $4,000 to one. So those limits are gone, and I think we can anticipate that that fundraising in Maryland with an election coming up this year, a statewide election, is going to be a whole lot more robust than it might have been before the McCutcheon decision came out. Thus far, only we've listed the states that have aggregate contribution limits. Only 2, Maryland and Massachusetts, have announced as a matter of enforcement policy that they won't enforce their aggregate limits even though they remain on the books. These other states have not said anything publicly. The laws still remain on the books. So it's an area where I think you still need to be a little bit careful.
The other thing this means is that no more can anyone come to you with a PAC when you are trying to raise money for your PAC and they say, oh, I've maxed out. I've already hit my biennial contribution limit. Well, they haven't because they don't have one anymore. So that's one area where it should hopefully help if you've got any donors in that category.
I'm sure the donors are delighted about that.
Yes. Another area that we want to touch on briefly is the IRS rulemaking back in November, Thanksgiving week to be exact. The IRS issued a notice of proposed rulemaking suggesting that they were going to develop new rules for C4s and what they can and can't do for campaign intervention. At some level, it sounds great in the sense that there are going to be specific definitions, but on the other hand, what the IRS has done is created this new definition, or the proposed definition, of candidate-related political activity and decided that everything is candidate-related political activity. If you remember those non-candidate official events that I talked about where a city member of Congress comes to talk to your organization, the IRS would say if it's done within 30 days of an election, candidate-related political activity subject to the limits on campaign intervention. Your website that talks about the McCain-Feingold campaign finance law, when McCain's up for election within 30 days, that's campaign-related political activity. So it's taken a very broad approach. There were about 150,000 comments, most of them opposed to the IRS's rule. Many of you in the room have probably submitted comments. Our thought is that the IRS will probably kind of go back to the drawing board to think this one over a bit more. Of course, at the same time, we have the investigations of the IRS by a number of different House committees in terms of their targeting of various conservative groups. in the application process. So I think the IRS, it's going to surprise me if they have a rule in place for this election, even though they had originally said they wanted to have one. And I think it'll be sort of down the road. I expect to be quite different than what was initially proposed.
And just to kind of refresh everyone's memory, and Ron, correct me if I'm misstating it, but this all comes about because 501c4s and C6s, but C4s have been the ones that seem to have been used the most for political campaign-related activity, have this general fuzzy rule that they're allowed to engage in political activity if it's not, what is it, substantial, if it's not the primary activity of their organization. It's generally been interpreted to mean if it's not more than half of their overall activity, but there's been no black and white rules, no lines, and that's what the IRS is trying to do here, was to in their view, kind of better define where those lines are so you can figure out what is too much political campaign activity. But as Ron said, they've defined it to include so many more things than people were considering before. And there's also great expectation that even though these specific proposed regulations are limited only to 501c4s, C6 organizations, trade and professional associations, are subject to the same basic limitation. So there's a wide expectation that if anything gets adopted in this area, it'll likely end up being applied to trade associations as well.
Yeah.
So while the FEC has become a virtual bystander in regard to its own statute, issuing very few regulations since the Citizens United case was decided, deadlocking 3-3. There are 6 members on the commission, 3 Democrats, 3 Republicans, deadlocking 3-3 at sort of unprecedented levels. The states are plowing forward to regulate where they can, and as I mentioned earlier, that primarily is in regard to disclosure. So we've seen a lot of activity, both in terms of litigation and new rules and new laws at the state level to try to flush out the identity of donors where contributions are passing through a nonprofit on their way to a candidate or to support a ballot measure. So that lawsuits have been filed, very prominent lawsuit in California that we wrote about a couple of times on our blog. The state of Washington has filed a suit against the Grocery Manufacturers Association to try to force them to disclose information about donors who contributed to their organization, where the donations were then used in connection with a ballot measure on genetically modified food. The state of Idaho filed suit against an organization that claimed that it was not required to register as a ballot committee, another 501c4, and succeeded in court before the election in compelling the organization to disclose of its donors. So a tremendous amount of activity in litigation and as I said, in disclosure rules. One of the most interesting is the rules that were issued earlier this year, late last year, by the New York Attorney General that requires an entirely new category, new levels of disclosure of political spending by 501c4 organizations. And you might wonder how it is the New York AG has authority to do this. And the hook is that the New York Attorney General is responsible for the state's charitable registration law. And it's a broad law that includes not just traditional charities, but lots of 501c4 organizations. So if you're raising money in New York or you're doing business in New York, you're probably registered under this New York charitable registration law. And those organizations will be required to disclose all kinds of things about their election-related activity, again, defined awfully broadly. So they create a term called election-targeted issue advocacy, lots of which, as the AG defines it, will have very little or nothing to do with the election. There's nationwide disclosure. So if you're doing election-targeted issue advocacy in states other than New York, cities across the country, all of that now has to be captured and included on an annual report with the state attorney general if you are registered under their charitable registration law. So again, lots of movement in that area.
Does that apply to C6s as well?
You know, the guidance issued says that it only applies to 501c4s.
No, but I think what we're thinking about, and we did put out an alert on this last year, the AG also came out with rules that apply to New York Incorporated entities that require new disclosures in this area as well. And the reason this has gotten so controversial is not only for folks that are based in and incorporated in New York and operating there, but if you happen to be incorporated in New York but you're operating across the country, these sorts of disclosures that are mandated cover all of your nationwide activities. And it's actually there's rarely an occasion when clients come to us and say, well, we're incorporated in a particular state. We really don't like the state nonprofit corporation statute. We'd like to think about reincorporating elsewhere. 99% of the time, the organizations decide not to do so because it's just not worth the effort. There's not enough benefit. This is the first instance where I've ever seen in my career where I think in some organizations it is in their best interest to reincorporate or domesticate in another state, assuming those disclosure requirements stand, because they are very significant. And for certain trade and professional associations, that's a major consideration.
Another area where we've seen with California is that if you're registering to do solicitations in California, the Attorney General has said, well, now we want to see your Schedule B from your 990. Now, your Schedule B is submitted to the IRS. It lists your donors, but it's not a public document. The IRS doesn't release that to the public. When you release your 990, you're not required to release the Schedule B. Most organizations filed a redacted Schedule B with the California Attorney General, and now she has said that that's not good enough. She wants the unredacted Schedule Bs, and so there's a lawsuit challenging that as well. So if you're registered in California, keep that in mind as another area that comes into play. And finally, an area that's maybe not directly applicable to you all, but could also cause disclosure, is a new trend that's been developing over the past few years of shareholders and other good government groups trying to get corporations to disclose their political activity. Sort of a groundswell of these good government type groups pushed this issue after Citizens United because they were all convinced that corporations would start spending all of their money on independent expenditures, which is actually proven to be not the case. Most of it is done through wealthy individuals when there's a lot of spending on the independent expenditures. But what they've tried to do through these different shareholder rules is force the companies to disclose their political spending, and they define that very broadly to include sometimes the amount that they pay to trade associations that's used for political activity or that's used for lobbying purposes. So you'll see as some of your member companies develop disclosure rules or disclosure policies to deal with these issues, that they have on their websites the amount they pay to their associations or the amount that goes toward lobbying or for political activity to their associations.
A lot of pressure has been exerted in this area by the pension fund managers of cities and states because they have so much invested in certain major corporations and not so major corporations. They have insisted, New York has sort of again taken the lead here, insisted that companies where they're heavily invested do more by way of public disclosure of dues they pay to trade associations that are used for lobbying, require that the associations make more disclosure regarding the donors. I think the New York City pension manager issued a public demand last week that a corporation they were heavily invested in disclose publicly that it had made contributions to a 501c4 gun rights organization. So there's again a lot of move at the state level to force more transparency and particular identity of donors.
So we've obviously covered a lot of material today. We'll open it up for questions now. As a reminder, as Jeff mentioned before, there's a lot of material that we have available online on our website. We have a political law briefing blog that we try and use to communicate sort of routine updates on when new things are happening. So we hope you'll be sure to check that out and subscribe to get the daily updates when we are posting. So we'll open it to the floor for questions now.
That question here in the front. Can you raise your hand?
I just have two quick questions. When you were talking back about board memberships, and it lists the C3, C4, PAC, and Super PAC, was that also applying to 501c6s as well?
Yes. Okay,
because question I'm getting at is because we're a 501c6, and we just have a newly formed PAC advisory committee. So some of the members who may be on the committee may also be on our board. So.
Yeah, and I would say that the PAC itself is usually it's often a less formal committee than an actual board. So the overlap there could be greater. It could be completely comprised of board members if you wanted it to be. It's a little bit different than the other parts of the organization.
And there's this real quick question I had on the slide on firewalls between like independent expenditures. Like we have lots of members of Congress who we lobby, we work with their offices on a daily basis, and we also do fundraisers. What kind of were you trying to concern us about there or bring to our attention?
So doing fundraisers is okay because those are allowed to be coordinated with the candidate. It's only if you're funding independent expenditures, communications to the public that expressly advocate the election or defeat of the candidate that are separate from that can't be coordinated.
Good presentation, Ron and Lawrence and Jeff. Thank you so much. Couple quick questions. One is, can corporations give in-kind contributions of services, mail, television, phone calls, emails, text messages, to super PACs? Can they give an in-kind contribution of services? And I know it needs to be disclosed, but can a corporation do that?
Yes.
Do you have to disclose the officers of the corporation or any of the customer lists that go along with that?
At the federal level, no. It would just simply appear on the recipient committee's report as an in-kind contribution from the corporation. Remember that super PACs are also operating at the state level and now even at the local level, and there may be other disclosures required.
One other question there. In the FEC guidelines, they consider a text message an inconvenient disclaimer attitude. As text message is 144 characters long, is there any disclaimer requirement for a text message being sent for federal or state candidates?
At the federal level, the FEC said no, not for text messages. Some of the states have been a little bit wishy-washy on that. I think California has tried. I'm not quite sure what the outcome of that was, but at the federal level, text message doesn't need a disclaimer. You're welcome.
And we have a question from the webcast, although it's a little bit unclear what the question is. We are working with a 501c4 organization that has a connected PAC, and the question relates to Form 990 reporting. Does the connected PAC just get reported on Schedule C of the 990, or does it get reported in the body of the Form 990 as well? And I don't know if I can answer that without looking at the form itself. I don't have that exactly memorized. Schedule C is the new schedule that the IRS created to focus on lobbying and political activity of tax-exempt organizations.
It definitely gets reported on Schedule C.
Yeah.
I don't remember if there's any other spot on the body of the 990 where it gets reported.
But it raises a good point to keep in mind, and that is with the IRS overhaul of the Form 990 a few years ago, there's a lot more reporting of both lobbying and political activity of tax-exempt organizations as well as affiliates and subsidiaries of tax-exempt organizations. There's just simply no chance, unless you're willfully withholding information from the 990, that you can avoid disclosing a lot of these activities and relationships and expenditures like you were able to in the past. And so that's just something to be cognizant of. And when we go back to things like overall disclosure and what you want to keep confidential and what you don't, certainly when you're a tax-exempt organization, there's a lot more disclosure involved. And as you all well know, the Form 990 is a very publicly available document. And so that's something to keep in mind in deciding what sorts of entities you want to utilize for various purposes. We're out of time. I want to thank Ron and Larry for a terrific presentation covering a lot of material in a short time. Thank you all for joining us, and we hope to see you back here next month. Thank you.